Mr. Partasides.
My lords, my ladies, I appear for the International Court of Arbitration of the International Chamber of Commerce as an intervener in this appeal, and let me say that I will try to avoid repeating the submissions of my learned friend Mr. Kimmins on behalf of the LCIA, although I fear some repetition may be unavoidable, and I would submit that some repetition may indeed be relevant, because the ICC Court, the LCIA Court, and the Chartered Institute of Arbitrators appeared before you together as institutions representing a broad international constituency of arbitration users with the same or similar concerns about aspects of the Court of Appeal's judgment.
Could I just mention that judgment was handed down roughly 18 months ago, and it would be interesting for us to know of any practical consequences that it has had in relation to London as the choice of London as an arbitration centre.
I'm not aware of any yet, my lord, although it may well be that the international community is holding its breath. Now, on the let me begin, if I may, by stating the ICC Court's position on the two issues before you. On the first issue, it is the ICC Court's position that multiple appointments concerning the same or overlapping subject matter with only one common party may, depending on the circumstances, give rise to an appearance of bias. If the Court of Appeal's judgment was to this same effect, which is possible but presently insufficiently clear to the international community, then we respectfully submit that it should be clarified. If the Court of Appeal's judgment holds that such a multiple appointment can never, by itself, give rise to an appearance of bias, then rather like the LCIA's, the ICC Court's position, respectfully, is to suggest that this is out of step with international standards today and should be reconsidered. On the second issue, it is the ICC Court's position that a failure to disclose multiple appointments in related matters with one common party may be sufficient, without more, to justify a disqualification. And that is because this is a particular circumstance in which the non-disclosure itself creates a situation of inequality between the parties. Because of this, the ICC Court respectfully submits that the Court of Appeal gave insufficient weight to non-disclosure in the circumstances of this case, again in a manner that is out of step with international standards today. Now, before I seek to explain those positions, let me say a few words about the ICC Court's particular interest in the outcome of this appeal. I hope, my lords, my ladies, you've had the opportunity to see the ICC Court's description of its place in the world of arbitration and why it has an interest in safeguarding confidence in the international arbitration process, not only in London, but beyond. The ICC Court supervises arbitrations conducted pursuant to its own rules, of which there have been approximately 24,000 to date. Most relevantly for present purposes, this supervision includes deciding challenges against arbitrators, and in the 5 years leading to the beginning of this calendar year, the ICC Court has decided over 230 such challenges. Now, in deciding those challenges, the ICC Court takes account of its own accumulated internal experience in deciding challenges. It takes account of international sources such as the IBA guidelines and conflicts of interest, and it also takes into account the law of the place of arbitration. So English law will be taken into account in deciding challenges in London-seated arbitrations. And given London's prominence as a seat of ICC arbitration, it's the second most popular seat of ICC arbitration, and the ICC Court's interest in maintaining a consistent treatment of challenges across its entire caseload, English law may impact other ICC arbitrations as well. Now, it is right, of course, that the ICC Court is free to disregard English law if it considers that it diverges from the international standards it applies. But in a global system such as international arbitration today, significant divergences in common standards across the major centres of international arbitration are less and less common, and if a new divergence were to arise, we submit it would lead to unfortunate confusion amongst users and arbitrators alike, confusion that will in turn affect the confidence in the system, and that is why the ICC Court is before you today. Now let me turn specifically to the two issues in this appeal. And on the first issue, let me begin by observing that other than in particular sector subspecialisms, as reflected in the interventions of GAFTA and the LMAA, multiple appointments in interrelated cases are far from being the norm, or indeed even common in international arbitration more generally. When such multiple appointments do occur, as the Court of Appeal itself recognized, they are understood in the international arbitration community to raise particular questions that can make them objectionable. Specifically, even if a risk of prejudgment does not arise, and as the Court of Appeal also recognized, a multiple appointment can create a problematic inequality between the parties by putting the common party in a privileged position of having unilateral access to the common arbitrator on related facts and issues, and by putting that common arbitrator in a position of having information on those same facts and issues that has not been derived from the parties' case presentations in the particular arbitration in question. And that is why the ICC Court takes a particular approach to challenges involving multiple appointments. Now, that particular approach is recorded in the ICC Secretariat's Guide to ICC Arbitration that I'll invite you now to turn to, and that you'll find in Intervenors Volume 1, Tab 6, at page 258, and that's reference 0259 to the electronic bundle. So at page 258 of tab 6 of volume 1, at the top of that page you'll see the guidance that the ICC Secretariat gives of court practice. It describes it as different. In this context, that means particular, where an arbitrator has been involved in some capacity in a case that is actually related to the arbitration at hand. In deciding such challenges, the court takes into account whether the arbitrator had or may have access to information that is relevant to the case, but is not available to all of the parties or their counsel, with the result of inequality in the access to the information. So that is the guidance, and it is also reflected in the ICC Court's case decisions, my Lord and Ladies. Now, sanitized digests of ICC Court decisions are published relatively regularly. You have some examples in your bundle. One example is the decision digest published by a former Secretary General of the ICC Secretariat, Anne-Marie Whitesell. And although in the interest of time I won't take you to it, I will give you some references to cases in which the ICC Court refused to confirm the appointment of an arbitrator who had been appointed more than once by one common party in related cases, and that's reference volume 1, tab 6, pages 211 and 212, or electronic bundle references 0212, 0213, and the cases that are described therein, sanitized descriptions of cases, are cases 7 and 8 that you will find on those pages. Now, let me be clear that these concerns of inequality of knowledge should not be misunderstood as an expectation that an arbitrator will come to a case with an entirely unencumbered mind, or tabula rasa, to use the phrase employed by the first respondent in its written case. Now, Webster's Dictionary defines tabula rasa as an initial state of mental blankness, and I think we can all agree that that is not what one is looking for, or indeed expect, although sometimes one might find it in one's arbitrator. But while a party is not entitled to expect an entirely unencumbered mind, it is entitled to expect a mind that has not been relevantly encumbered by the adverse party in a related matter by reason of multiple appointment. And because of this, you'll find ICC and other cases in which multiple appointments in certain circumstances have resulted in challenges being upheld. And you'll also find, as you've seen in the parties' writings, the opposite. The common feature each and every time is, whatever the outcome, the challenge is considered in the circumstances. And this rather obvious proposition brings us to the concerns that the Court of Appeal's judgment on this issue has given rise to internationally. Because in holding that a multiple appointment is insufficient of itself to establish an appearance of bias, and that something more is needed, the Court of Appeal has at the very least introduced some uncertainty as to the position under English law, because multiple appointments cannot be considered in the abstract in and of themselves, because there is no such thing as an abstract appointment, because every appointment, if you prefer, is embedded in circumstances. So depending on those circumstances, something more may not be required to give rise to a reasonable apprehension of bias. Or put another way, the something more may be nothing more than the particular circumstance of the multiple appointment in question. Now, this may be what the Court of Appeal meant in holding as it did on its first question. If that is so, that is certainly not sufficiently clear from the international arbitration community's perspective. That is why you have heard of this chorus of disquiet, and that is why this decision, we say, should be clarified. But if the Court of Appeal meant that such multiple appointments can never, of themselves, give rise to an appearance of bias, as might be understood by the reference to something more, something substantial, it is the ICC Court's respectful submission that this puts English law out of step with international standards today and should be reconsidered. If it remains thus, and there will come a time when people stop holding their breath, my lords and my ladies, then it will no doubt lead over time to a rich, but from an international perspective, a rather bewildering body of cases on a potentially additional criteria for a challenge to be successful in such a case that presently does not form part of international standards and practice on this issue today. So I move to the related second question, the duty of disclosure and the consequences of a failure to fulfill it. And let me begin by making clear the importance that the ICC Court attaches to the pro-disclosure international consensus that exists today, and that I do not think is controversial in this court. Like other major international arbitral institutions, the ICC Court considers disclosure to be absolutely essential to preserve confidence in a system of justice in which parties select their judges, and I would add, in the context of this appeal, can select them again and again. This importance of disclosure is reflected in the ICC Court's note of guidance to parties and arbitral tribunals that circulated to every participant in ICC arbitration at the very outset of such proceedings, and I would like to turn your attention to it. You'll find it in the Authorities Bundle Volume 2, tab 52, at page 531, and that's reference 1405 in the electronic bundle. And I'm going to ask you to turn to page 531, which, apologies, that's not right. Yeah, page 531, which is 1405 in the electronic bundle. This is a section of the ICC note that deals with matters of disclosure. I think it bears walking through it together briefly. Let's start with paragraph 20 at the top of the page, where you will see that the ICC Court's guidance to arbitrators is that parties have a legitimate interest in being fully informed of all facts or circumstances that may be relevant in their view in order to be satisfied that an arbitrator fulfills the relevant standards. And you'll see at paragraph 21, the final sentence of that guidance, that the ICC court instructs that any doubt must be resolved in favour of disclosure. Now, I will return to paragraph 22 shortly. For now, let's move on to paragraph 23, which sets out particular circumstances that will be relevant to a disclosure, and I invite you to focus in particular on the last 3 bullet points of those circumstances, which specifically call for disclosure of multiple appointments, including the penultimate bullet point dealing with appointment in related matters. Now, this ICC guidance today is entirely consistent with the IBA guidelines, which you've heard about, and which I think we can all agree broadly are considered today to reflect an international consensus in international commercial arbitration on these issues, and which were drafted, I should say, by an IBA working group on which I and my learned friend, Mr. Landau, appearing for the first respondent, participated in 2014. And as I think you've heard, in those IBA guidelines, there is specific requirement that multiple appointments in related matters with one common party in the last 3 years be disclosed and be disclosed at the earliest possible juncture. That's paragraph 315 of the IBA guidelines, which you'll find at volume 2, tab 48, page 506 of your bundle. That's electronic reference 1380. Now, let me acknowledge that there is much in the Court of Appeal's judgment on the importance of disclosure that is consistent with the submissions that I've just made. But it is the ICC Court's position that although the Court of Appeal recognized the importance of disclosure, it proceeded to undermine that recognition by giving insufficient weight to the non-disclosure that occurred in this case. In particular, while it found that the circumstances might be cause for legitimate concern, that they ought as a matter of law to have been disclosed, and indeed that non-disclosure of circumstances that ought to have been disclosed inevitably, that's the Court of Appeal's word that you'll find at paragraph 74, inevitably colours the thinking of the observer, it drew no consequences from the non-disclosure of such multiple appointments absent other factors. As a result, we say, respectfully, that this leaves English law out of step with international practice today. Now, on this, let me return to paragraph 22 of the ICC's Note of Guidance, which again you'll find at volume 2 of the Authorities Bundle, tab 52, page 531. That's electronic reference 1405 again, because you'll see in the final sentence of that paragraph reference made to the general position that a failure to make a disclosure is not in itself a ground for disqualification. Now, while that is right as a generality, at the first step into specificity, the ICC Court's position and practice is that non-disclosure may be sufficient without more to justify disqualification in particular circumstances. And for present purposes, the relevant instance is where the non-disclosure itself creates a situation of inequality between the parties, and a failure to disclose multiple appointments in related matters with one common party is such an instance. Now, examples of the necessary inequality have been provided in paragraph 43 of the appellant's written case, with which the ICC respectfully concurs. Because arbitrations in London are private, absent disclosure, the common party alone will be in a position to conduct itself in the arbitration in light of its awareness of the common arbitrator's experience in those related proceedings. And the non-common party, the party in ignorance, to use Lord Gravener's phrase, will be deprived of the knowledge and opportunity to assess the implications of the multiple appointment with overlapping subject matter. And so it is the ICC Court's position that these facts produce an inequality. The arbitrator has created the inequality by the non-disclosure, and therefore that very non-disclosure can, without more, itself justify disqualification. Again, you can see examples of ICC court decisions that reflect that practice. Again, they are contained in the sanitized digest of ICC decisions that you have in your bundle. For present purposes, let me give you just two references to them. The first is a decision of the ICC court not to confirm an arbitrator appointment in a related multiple appointment scenario. It appears at page 210, Volume 1 Intervenors Bundle, tab 6, page 210, or page 211 of the electronic bundle. The second...
Sorry, which case is it?
So this is case number 1.
Case 1, thank you.
On page 210.
Yeah.
You'll see that it's a case of non-confirmation in circumstances of a non-disclosure of a multiple appointment in related matters. The second is case number 5, my lords, my ladies, that you'll find on page 218 of the bundle. It's described as case number 5. This is referenced 0219 of the electronic bundle, which was a decision this time to uphold a challenge to an arbitrator, again for non-disclosure. And the undisclosed relationship there, you will see, was a relatively remote relationship. It was a relationship not with the party in interest, but a relationship between an arbitrator's law firm and the auditor of one of the arbitrating parties. And that suggests how much significance the ICC court attached to the non-disclosure as much as to the underlying circumstance. Now, these are examples of the ICC court's past decisions in which substantial weight is given to the fact of non-disclosure. In appearing not to attach similar significance to the non-disclosure in this case, the Court of Appeal emphasized the accidental nature of the non-disclosure, by which it meant, as we all know, Arbitrator M's decision, notwithstanding that he did turn his mind to the question, that he was not obliged to make disclosure. This even though he did make disclosure of the multiple appointment in the corresponding transocean arbitration. And in so doing, and here we find ourselves in a very similar position to the LCAA, it is the ICC court's position that the Court of Appeal attached too much significance to what it described as an accident. The international pro-disclosure consensus that I refer to and that the ICC court fully supports would be considerably weakened, we say, if an arbitrator could simply rely on his or her honest but wrongful conclusion that disclosure was unnecessary, subsequently to explain away that wrongful non-disclosure. For all these reasons, the ICC court respectfully submits that the Court of Appeal gave insufficient weight in the circumstances of this case to the non-disclosure. It submits that the position under English law should be that a failure to disclose such multiple appointments in overlapping matters with one common party can be sufficient, without more, to give rise to a justifiable doubt as to the arbitrator's impartiality. And we submit respectfully that in confirming that position, my lords, my ladies, you would do much to address the concern that has now arisen that English law is somehow less strict on matters of disclosure than other leading centres of international arbitration today. Thank you very much.
Thank you very much, Mr. Particides. Mr. Crane.
Lords and ladies, may I start by telling the court how Mr. Landau and I plan to divide our allocated time. I will respond to the appeal initially on the facts because we've been at the level of general principle so far, and it's important to nail the particular facts of this case down, but also to cover, and I've done that, the relevant legal principles in English law. Mr. Landau will then address the proposition that the judgment of the Court of Appeal puts this jurisdiction out of line with an international consensus in the major jurisdictions, and will demonstrate, I have confidence that he will demonstrate, that the reverse is true. He will also address some questions on the construction of the Act relevant to the issues in this case, but we'll split that between ourselves. Before I come to the salient facts, and they're all facts which derive from the evidence and the material before the courts below, there's nothing new here, or nothing not covered by the evidence. Can I set the context in which these facts have to be considered? Because there has so far been a certain amount of confusion about that. And we can see the context from the Court of Appeals judgment, Core tab 9, paragraph 73, at page 194 or 195 in the electronic bundles. Now, here the Court of Appeal make it clear that they are engaged in a two-stage process. They say there are, as it seems to us, two distinct questions for the court considering an allegation of non-disclosure after the event. First, the court needs to consider whether disclosure ought to have been made in accordance with the principles we have just enunciated. Secondly, the court needs to consider the significance of that non-disclosure in the context of the application with which the court is dealing under Section 24. In the case of an application for removal of the arbitrator in question, the court will consider on the basis of all the factual information when that application is heard, including the fact that there has been non-disclosure, whether the fair-minded and informed observer would conclude that there was a real possibility that the arbitrator was biased. Now, this is a fundamental part of the case. And what the Court of Appeal is saying is that the two issues fall to be dealt with at different times and quite often on the basis of different material. Whether an arbitrator was in breach of an obligation to disclose a circumstance must be considered on the basis of what was known or is to be imputed to the arbitrator at the time when it is held. He ought to have performed the relevant duty. In contrast, whether justifiable doubts exist as to the impartiality of an arbitrator, or whether in the mind of an observer there would be there would exist a real possibility of bias, is an overall assessment to be made on the basis of all material before the court at the time of the hearing in question, whether it's a first instance court or indeed an appellate court, assuming the evidence has developed in the interim. And the reason for that is that we are considering two completely different questions. The first, self-explanatory, whether there was a breach of the relevant obligation to disclose. The second, whether in all the circumstances, including that, the serious step of removal is justified. In other words, you can infer from the totality of the material before the court that there are justifiable doubts as to the arbitrator's impartiality. Now, that does not mean, as Lord Grabbanner with respect suggested, that having found a breach of an obligation to disclose, the Court of Appeal illegitimately used hindsight to exculpate the arbitrator. We're dealing with different questions to be determined on different material at different times. And there are authorities on this, to which I will come probably tomorrow. But for the moment, if we can then see how the Court of Appeal deal with it at paragraphs 94 and 95, consistent with that approach. This is page 198, 199 for those working from electronic pagination. There they say, we conclude that M ought, as a matter of good practice, and in the circumstances of this case, as a matter of law, to have made disclosure to Halliburton at the time of his appointments in references 2 and 3. The question then becomes whether at the time of the hearing to remove, the non-disclosure taken together with any other relevant factors which would have led the fair-minded and informed observer, have considered the facts to conclude there was in fact a real possibility that M was biased. So again, the two-stage process. The second question being determined on the totality of the material, and it's a holistic analysis. Now, that means, we would respectfully suggest, and we'll come back to this, that the quality of the non-disclosure, by which I mean whether it's inadvertent, innocent, or deliberate, along with the circumstance that's not disclosed, has to be assessed and imported into the second inquiry, namely whether in all the circumstances an appearance of bias or a real possibility of bias exists or justifiable doubts exist as to the arbitrator's impartiality. Now, I'll examine the authorities on that, if I may, in due course, but that's the context in which I look at the facts. Now, within that context, the facts that I'm briefly going to identify establish two things. The first, we submit, is that given the relative timing of the two arbitrations, namely the Halliburton reference and the first of the Transocean references, there was never any real risk that the Transocean arbitration could affect the course or outcome of the earlier Halliburton reference. And that obviously is a factor which will be taken into account by the court when it comes to examine or decide what disclosure M ought to have made in that context. So that's the first proposition. The second is this. When the facts are boiled down, what we have here is Halliburton seeking to have the arbitrator removed for what is admittedly an inadvertent and an innocent omission to disclose something which caused Halliburton no unfairness at all and did them no harm. Now, Lord Grabbanner would say, well, that's irrelevant because that's hindsight, to which I reply, it's central to the second stage of the inquiry that I've just described. Now, my lords, my ladies, with that background, can I just pick out a few points, and I'll do this quickly. The first, we ought to look at the nature of M's disclosure to the appointing court on the Section 18 application. And we'll find that summarised by Mr. Justice Popperwell at tab 12 of the core bundle, page 208, or if you're working electronically, page 209. At paragraph 9, after a reference to M's reputation, he says this: he has extensive experience of both domestic and international arbitrations governed by the Act and of arbitral procedural law, practices and procedures. He has sat as a member of an arbitration tribunal in over 30 references concerning the Bermuda form over many years. And that's taken from the CVs of the various candidates who were put forward. And then there's a reference to his reputation. Prior to expressing his willingness to be appointed, M disclosed that he had previously acted as arbitrator in a number of arbitrations to which Chubb was a party, including appointments on behalf of Chubb, and that he was currently appointed as arbitrator in 2 pending references in which Chubb was involved. Now, just for the court's note, we needn't go to this, but the disclosure email in question may be found at volume 2 of file S, tab 19, 392, 636 in the electronic bundles. And what becomes apparent from that document, which is not apparent from Mr. Justice Popperwell's summary, is that in the two pending references, M was sole arbitrator appointed by both parties in one, and in the other he was appointed by Chubb, and the other party appointed arbitrator was N, Halliburton's appointed arbitrator in this case. Now, it follows from his appointment that the commercial court, in the shape of a very experienced judge, did not regard the fact of M's prior involvement in references involving Chubb, or his involvement in pending arbitrations involving Chubb, as giving rise, as being objectionable. Now, perhaps more importantly, it's clear from the evidence filed on that application that Halliburton accepted that repeat appointments on behalf of insurers did not give rise to an appearance of bias. In other words, they didn't create justifiable doubts as to an arbitrator's impartiality, albeit they may cause concern to American policyholders who are used to a polarized system and indeed are used to a system which distinguishes a neutral arbitrator, call it the chair or presiding arbitrator, from party appointees who are referred to in at least one American case as de facto advocates. But if we can just look briefly at what Halliburton said about this in May of 2015, we find that at volume 1 of S, tab 3, page 44, or page 288, if for those working from electronic files. And this is a witness statement filed on the Section 18 application by Halliburton's solicitor, Mr. Meredith. At paragraph 101, he says, in the United States, the practice of insurance law has developed over recent years such that law firms and lawyers with experience in insurance law are seen to be associated with acting for either insurers or policyholders. Increasingly, that degree of specialization is present in the London market. On a global basis, my own law firm, K&L Gates, only acts for policyholders in disputes over insurance coverage. As a result of my firm's prominence in the representation of policyholders, we are commonly instructed in London-seated arbitrations, including Bermuda form disputes, where the insurers propose as chair English QCs, whom we know to be currently serving or who have previously served as counsel to an insurer in a separate dispute where we represent the policyholder. Just pausing there as an aside, M, of course, didn't fall into that category. For many years, he had not been a practicing QC. Insurers also commonly propose as chair of the tribunal English QCs who are currently serving or have previously served as a party-appointed arbitrator appointed by an insurer in a separate dispute where we represent the policyholder. Now, pausing there, this, as I understand it, presages the mixing and matching objection to which Lord Grabbanner referred this morning, namely that it is objectionable for a chair, given the special position as he would have it of the chair, to be appointed concurrently by a party to the first arbitration. Now, clearly, that was a situation, again, apparent to the appointing court, because M was appointed as a chair in the Halliburton reference, notwithstanding a concurrent appointment in a pending reference by Halliburton, and notwithstanding that he was also sole arbitrator in another pending reference. And then at paragraph 104, we have this, and this is important. While it is recognized that prior representation of insurers or appointment by insurers does not constitute circumstances that give rise to justifiable doubt as to his impartiality within the meaning of section 24, it can create a perception of unfairness, particularly to a US-based policyholder that is accustomed to the polarization of the insurance bar. And then there's a reference to ACE's informational advantage. But over the page at 289, at 106, we see that Mr. Meredith tells us that ACE's informational advantage is counterbalanced to some extent by the fact that my law firm represents other policyholders in Bermuda former arbitrations, and on he goes. So it's quite clear that if we focus on the position not of Halliburton, because you don't expect policyholders to be frequent visitors to London arbitrations, but their lawyers. And in the case of Bermuda form arbitrations, you will typically find that the American policyholder is a big corporation that appoints either major London firms or major American firms with substantial London presences like K&L Gates or I can't think of any others for the moment. Reed Smith is an obvious example. Or you get Freshfields or some other major London firm acting for the policyholder. So that was the evidence at the time of the appointment. Can I draw from it the fact that additional appointments in unrelated references were not considered either objectionable or problematic, by which I mean additional appointments by a party to the instant arbitration. I'll deal with the overlap of subject matter presently. The next point, and we submit it's important, and until a question from the court this morning had been overlooked, is the relative timing of the two references. The Halliburton Tribunal was constituted by the order of Mr. Justice Flo in, I think, mid-June 2015. I think it was the 12th of June, but I might be wrong on the precise date. By the time M accepted an appointment in the Transocean reference, the Halliburton reference was 6 months down the line, and a full and detailed statement of claim and defence had been served. In the event, of course, the Transocean Tribunal was not fully constituted by his acceptance. That was sometime later at the beginning of the following year. Now, the point of that is that if one looks at that timing in the context of the difficulties said to be inherent in acceptance of appointments in overlapping references, one starts from the position that it's highly unlikely, if both arbitrations go the distance, that Transocean will be decided first. In fact, the reasonable supposition is that the opposite will be true. And if one then asks what the relevance of that is to the twin vices said to be inherent in acceptance of concurrent overlapping arbitrations, you have two. My learned friend Mr. Kimmins described the first as the ability to have a dress rehearsal. And that was inside information. The second has been described as the ability to have private or ex-parte communications. That ability being to the disadvantage of the common party, of the non-common parties. Now, if one asks why M should have made full and comprehensive disclosure to Transocean to put them in the picture, but overlooked the fact that the corresponding obligation was owed to Halliburton, if that be the case, although his position, quite honestly, and it's always been accepted, is that it simply didn't occur to him. He was under an obligation to disclose this appointment to Halliburton. But why should that be? We would submit that it makes sense to tell the non-common party in the arbitration proceeding second, 6 months behind the first, that you are already appointed in a pending reference arising out of Deepwater Horizon. That's pretty well what he knew. It would be the non-common party upon whom, the non-common party in the second reference, upon whom the exclusion from the dress rehearsal would be a disadvantage incurred. It would be the non-common party, again, assuming these objections are valid, who would be excluded from the possibility of observing the tribunal's response to issues and arguments in the first reference and adjusting its position accordingly. And if there was complete identity of overlap, it would be the non-common party in the second reference that would not be party to communications between the tribunal and the parties in the Halliburton reference that had a direct bearing on the issues in the second reference. Now, I don't accept that these are the problems they're maintained to be for reasons that I'll develop subsequently, but let's just assume, for the sake of argument, that they are valid. In our submission, although he never gave his mind to it, it makes perfect sense that it should have occurred to M to make full and proper disclosure to Transocean of his previous relationship with Chubb in the sense of involvement in arbitrations in which they were involved, on the one hand, and on the other, of the fact that he was currently appointed by the court in a pending reference involving Halliburton and arising out of the Deepwater Horizon incident. And I think if your lordships and ladyships would excuse me, I think it bears looking at the disclosure that he gave to Transocean. We see it at Bundle S, Volume 1, tab 11, page 198, and page 442 in the electronic bundles. And you'll see that that's an email at the top of the page from, it's from Clyde & Co. to Jones Day, who were Transocean's solicitors in these arbitrations, passing on or forwarding an email sent to Clyde & Co. by M on the same day, making disclosure. And he says in the second paragraph, I'm aware of no conflicts, and in principle I should be delighted to accept, provided there's no real risk. And then he refers to a desirable end date for this reference. As you are aware, having practiced as a full-time international commercial arbitrator over the past 18 years, specializing in insurance and reinsurance disputes, I've acted as party-appointed arbitrator and chairman in many Bermuda form arbitrations, a number of which, not surprisingly, have involved ACE, who have appointed me as their nominated arbitrator on various occasions. So that's what he told Mr. Justice Popplewell, effectively. I've also previously acted as chairman in 2 other arbitrations in which ACE Bermuda was a party. Currently, I have only 3 pending cases involving ACE. In one, I'm their appointee. In the second, I've been appointed as sole arbitrator by agreement between the parties. And in the third, I've been appointed as third arbitrator by order of the London Commercial Court. The last of these also happens to involve what I understand is a different aspect of the Deepwater Horizon incident. Now, that's his state of mind at the time. And the question we respectfully submit for the court is that whether, assuming an obligation to disclose circumstances which could, in the mind of the objective observer, give rise to an apprehension, the real possibility of bias, or assuming a practice to that effect, was M's disclosure to Transocean in the circumstances in which I've described, performance of that obligation or adherence to that practice. And my submission is that it was. Now, I'm not suggesting that that was his thought process, because if one looks at, perhaps we ought to do this, because there has been some really rather surprising debate as to whether this is a case where the arbitrator gave consideration to the matter and honestly, but wrongly, as it said, decided that disclosure to Halliburton of what he'd disclosed to Transocean was not called for, or whether it was simple inadvertence. And it's pretty clear from the correspondence that it was the former. If one looks at file S2, I think it is. Yes, file S2 at tab 19, page 394, electronic 638. This is his letter to K&L Gates. K&L Gates having written to him some days earlier, referring to the IBA guidelines, paragraphs 313 and 315, and saying, you've been in breach of those guidelines, we're extremely concerned, can we have an explanation? And in the third paragraph, beginning with the words, so far as reference to is concerned, M describes the circumstances in which he was appointed in the first of the two Transocean arbitrations. And he points out correctly that in his letter to Clydes, he accepted the nomination in principle, and then he goes on to describe what the court has already read, the material to which he alerted Transocean. And then the final sentence of that paragraph, it did not occur to me at that time that I was under any obligation under the IBA guidelines to inform you or your clients of this further appointment. And although this is clearly innocent inadvertence, my submission to the court is that the fact that it did occur to him to make this disclosure to Transocean so that they were alerted to his previous record in arbitrations involving Chubb, along with the pendency of a Deepwater Horizon reference, it makes perfect sense that it didn't occur to him to do the same to Halliburton, because given the relative timing, if a party was to incur any disadvantage through the concurrency of these appointments, it would highly likely be the non-common party in the reference running second. Now, may I invite the court to look at two pieces of two references which demonstrate the point that I've just been making. The first is to be found in volume 2 of the interveners files. It's the submission put in by the Chartered Institute of Arbitrators at tab 8, page 387, 388 in the electronic bundles. And the relevant paragraphs are paragraphs 42 and 43, where the authors of these submissions, the draftsmen, put forward a hypothetical, as they call it, to illustrate the difficulties, indeed the vices inherent in the situation which is said to confront the court. And they say that a common hypothetical suffices to demonstrate these problems. Assume an arbitrator A is nominated by a contractor C in a dispute with a subcontractor, S1, where an issue arises as the construction of the subcontract. That issue is resolved in C's favour. It would be wholly inappropriate for A, the arbitrator, someone who has participated in deliberations concerning the contractual dispute and made findings on it as part of the tribunal, to accept an appointment by C without disclosure in a parallel dispute arising out of the same project with a second subcontractor, S2, in which the same issue of contractual interpretation might arise. And then, helpfully, this hypothetical goes on to illustrate the fact that the disadvantage is suffered by S2, the party in the second arbitration. Were such an issue to arise in the second arbitration, S2 would not be aware, without disclosure, that at least one of its tribunal members had already made up his or her mind on the point, as it arises from the same subcontract document. It's not difficult to imagine what concern might be felt by S2 in learning of the common appointment and the prejudgment by A, and why the result, if in favour of C, would be automatically unfair. We submit this is wrong as a matter of English law, but nevertheless it's useful to illustrate the alleged problem. It is also not beyond the realm of possibility that in such a circumstance the party appointing A in the second reference or its counsel might already be aware that the same issue of construction is certain to arise even if at the time of the appointment A is entirely unaware of this. And we're grateful to the Chartered Institute of Arbitrators for elucidating the problem and pointing it out that it is specific to the non-common party in the reference that precedes second. Now, it may be said, it can be said, well, of course, unlikely things might happen. There may be a sudden cause of unexpected delay in reference 2 and an unexpected acceleration of a hearing date in reference 1, at which point the problems discussed might arise, to which I respectfully submit that one has to keep a sense of proportion here. The risk, when he accepted his appointment, that anything in the Transocean reference would affect the course or outcome of the Halliburton reference was small. Indeed, as time went on, it got smaller still. And if I may, can I just refer the court again to Guidant, a case that Lord Grabiner put before you this morning. It's at tab 10 of the authorities volume. And the headnote, which I'll start, is at page 130, page 1004 in the electronic files. Now, what one picks up from the headnote here is that, in contrast to two cases which the arbitrator simply knew arose out of the same man-made disaster, Deepwater Horizon, and involved two different insureds, presenting two different risks, in other words, covering their distinct and separate legal liabilities. This was a case where a party was appointing the same arbitrator in three different references in which the risk was the same, the policyholder was seeking to recover the same loss at different layers of its vertical program, and indeed, as Mr. Justice Leggett tells us at paragraph 7, I think it is, yes it is, where each of these covers was placed on the same insurance proposal. In other words, there was pre-contract disclosure common to all. So these are not references that may, we don't know, involve some common question of law or fact. These are identical claims, albeit, as the learned judge pointed out, one of them involved a claim for rescission and the others didn't. Now, in the context of that, if we go to paragraph 9, the legitimate concern to which Mr. Justice Leggett is referring in 1, 2, 3, 4, 5 lines down in that paragraph is a legitimate...
Paragraph 9, thank you.
It's paragraph 9, my lord. 5 lines down. if the same person were to be appointed, there would be a legitimate concern that that person would be influenced in deciding, etc. That was a legitimate concern which it was appropriate to take into account, as Mr. Justice Leggett found, in choosing an arbitrator to appoint under a Section 18 application where there is an unfettered discretion. And that legitimate concern in my submission is a concern that to the party involved, in other words, the party that might stand to suffer by being excluded from conversations of direct relevance to its case, to which the common party was privy. But again, just as in the hypothetical to which I've referred, if one goes to the last sentence in paragraph 9, one sees a distillation of the problem, the fundamental problem to which the court is referring. If the Markle arbitration were to be heard first, the members of the tribunal in that arbitration would form views without any input or opportunity for input from Swiss Re, from which they may afterwards be slow to resign. So again, this was a case where the claims were launched concurrently, it would appear. And the learned judge then says the first heard arbitration would give the opportunity for decisions to crystallize, at least provisionally, and they might be hard to shift subsequently. And then paragraph 10, to which you were referred this morning, but is obviously important to my case, here a clear distinction is made between the legitimate concerns in the context of a Section 18 application, which may be felt by the non-common party in the scenario described, a contrast between those concerns and the question with which this court is concerned, whether such circumstances give rise to justifiable doubts as to an arbitrator's impartiality. And there, Mr. Justice Leggett was quite clear that they do not. In other words, they wouldn't found an application to disqualify under Section 24. And when one comes to ask, why is that? It's because the courts start from a presumption that professional arbitrators will observe their obligations under Section 33 of the Act. It's not deference to some parochial reputation. And the obligation to act fairly between the parties involves considering each case solely on the material adduced in that case, or in the event that some extraneous factor is influencing the arbitrator's thinking, to put that factor before the parties in the reference in question and ask them to address it. And indeed, to decide a case, one gets this from time to time in Section 68 applications, where an application under Section 68 of the Arbitration Act is made to challenge an award, and on the ground of serious procedural irregularity. And there are two requirements. One is that substantial injustice must be caused, and two, there is a list of instances of serious irregularity, the relevant one of which is breach of Section 33 of the Act. Perhaps we might just pick that up before moving on. It's in A1. Tab 1, page 19, or 893 in the electronic bundles, where we see this, Section 68, challenging the award, serious irregularity. A party to arbitral proceedings may, upon notice to other parties, apply to the court challenging an award in the proceedings on the ground of serious irregularity affecting the tribunal, the proceedings, or the award. And then there's a reference to possible waiver. Serious irregularity means an irregularity of one or more of the following kinds, which the court considers has caused or will cause substantial injustice to the applicant. And then A is the relevant section, failure by the tribunal to comply with Section 33, general duty of the tribunal. And we can pick that up. It will, of course, be very familiar to this court at page 18, 892 of the electronic files, where 33.1, we see the tribunal shall act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting his case and dealing with that of his opponent. So were an arbitrator appointed in two related references involving common questions of fact or law, or identical questions of fact and law, to be minded to decide in reference A on the basis of material specific to reference B, it would be a breach of his obligation under Section 33 if he didn't put that material to the parties in the reference in question and ask them to address the court on it. And there's at least one case I can think of under Section 68 where an arbitrator decided the reference on a point that hadn't been argued or proposed by the parties, or which hadn't been raised with the parties, and that was a serious irregularity. So that may explain why Mr. Justice Leggett was so clear that while this was a legitimate concern in the context of a Section 18 application for the non-common party in the second reference, it did not found an application under Section 24 because it didn't give rise to justifiable doubts as to the arbitrator's impartiality. Now, Mr. Justice Popplewell, bearing in mind, I would submit that this is an ad hoc reference, not a highly regulated reference under the ICC or LCIA institutional rules, held or observed that it would have been proper for M to wait and see if a problem arose, even on the wrong hypothesis that overlapping subject matter was a disqualifying circumstance, something the judge didn't accept. And one can see this at tab 12 of the core bundle, at page 217, 218 in the electronic files. Sorry, it's 217, yes, 218 in the electronic files, at paragraph 36, where he refers to Mr. Kitchener making the point that M could not have been confident of the absence of overlap at the time of the appointment, nor equally could he have been confident that there was overlap, even on the false hypothesis that a degree of overlap disqualifies an arbitrator from acting in both references. There would be no apparent bias. That's the important assertion in accepting an appointment and remaining involved in the reference until any overlap giving rise to a conflict of interest became apparent. This sometimes occurs as arbitrations take their course, and the common experience in London arbitration is that where a genuine conflict of interest arises, arbitrators will tender their resignations in one or both of the references. Now, just looking at that, that's an important observation because it highlights the difference that an arbitrator, the different positions in which an arbitrator may find himself or herself, depending upon whether they're appointed ad hoc or the parties have agreed to refer their disputes to an institution such as the ICC or LCIA. Now, in the latter instance, both the ICC and LCIA rules provide for a fairly full exchange of documents before the arbitrator is required to make a disclosure statement. in both sets of rules, there will be a request for arbitration, which will have to identify the issues, say or state the basis upon which the claim is made, attach the relevant contract documents as well as the arbitration agreement. And then there is a period of time provided under the rules for the respondent to file its answer, which must have similar attributes. And one can see that in the case of the LCIA. We don't have the equivalent rules, or the equivalent rule from the ICC at Vol 2 of the authorities file, tab 54. Page 538, 1412, electronic numbers. And you'll see under Article 1, I won't read it, but you'll see the provisions regulating the contents of a request for arbitration, including particular Roman numerals 2 and Roman numerals 3. And then at 2, response over the page, 2.1 Roman numerals 3, you'll see the corresponding provisions which regulate the contents of an answer. And then what happens? Article 5, formation of the arbitral tribunal. The tribunal, of course, is not appointed by the parties. It's appointed by the LCIA court, or in the case of the ICC, the ICC court. Sometimes that's confirming party proposals, but the appointment is by the institution. Before the institution appoints the arbitrators, they're required to make disclosures in accordance with Rule 5.3 and 5.4. And you'll see that those disclosures are party-focused in the sense that they apply to circumstances known to the candidate which are likely to give rise in the mind of any party to any justifiable doubts as to his or her impartiality or independence. So although the doubts have to be justifiable, the focus is on party perception, which we know from all the authorities is a very different matter than the matter seen through the lens of an objective observer. And if one wants the corresponding requirement under the ICC, we'll see that at tab 50, page 526, page 1400 in the electronic files. And this again...
Sorry, the reference again, please.
I'm sorry, my lord. It's tab 50.
Thank you.
I'm sorry. It's tab 51. I didn't notice at the top of the page there was another tab, which means that it's 3:10, and those sort of mistakes may proliferate, for which I apologise in advance. So you'll see that, again, the scheme is the same, but the disclosure obligations in Article 11 2 are that before appointment or confirmation, a prospective arbitrator shall sign a statement of acceptance, availability, impartiality, and independence. The prospective arbitrator shall disclose in writing to the Secretariat any facts or circumstances which might be of such a nature as to call into question the arbitrator's independence in the eyes of the parties, as well as any circumstances that could give rise to reasonable doubt as to the arbitrator's impartiality. So again, anything that might call into question in the eyes of the parties the arbitrator's independence has to be disclosed, a very different test. And it's after such disclosure that the tribunal is appointed. Now, in contrast, in an ad hoc arbitration, the request for arbitration involves a nomination of an arbitrator, and the response to that request involves nomination by the respondent. And we see that in the standard arbitration clause of the Bermuda form in volume 2 of file S, at tab 16. page 362, 606 in the electronic bundles. Where it simply says this, under clause N at the foot of the page, after the indent, or the indented passage, any party may, in the event of such a dispute, notify the other party or parties to such dispute of its desire to arbitrate the matter, and at the time of such notification, the party desiring arbitration shall notify any other party or parties of the name of the arbitrator selected by it. The other party who has been so notified shall, within 30 calendar days thereafter, select an arbitrator and notify the party desiring arbitration of the name of such second arbitrator. And then there's a provision for default appointment and a provision for the two nominated arbitrators to agree the identity of the third or presiding arbitrator. So, in an ad hoc reference of the sort with which this court is concerned, and of the sort which will inevitably be the case in a Bermuda form arbitration, it is much more likely that an arbitrator will have no detailed grasp of what's in issue till he or she reads the pleadings. Clearly, the notification of dispute varies in detail, but it may well be the case that a tribunal appointed ad hoc won't be called upon to read lengthy pleadings and incur hours for which the clients or on respective sides will be billed until the first procedural reference. So wait and see may not be a course that commends itself to institutions such as the LCIA or the ICC, but it is much more likely in reality to be the case in ad hoc references. I mean, commonly, an appointment in an ad hoc reference will be preceded by the appointing party's solicitors asking the arbitrator to check a list of names for conflicts. And then, assuming that is cleared, there will then be a notification of a dispute and a response with an appointment of the respondent's arbitrator. And as I say, that will involve varying degrees of detailed information, some quite sparse, some others less sparse. But the only point here, and it's not central to my case, but it is one that I would respectfully invite the court to consider, is that there is no partiality, there is no possible bias involved in an arbitrator appointed in an ad hoc reference waiting until he gets or she gets some clearer idea of what's involved. And one doesn't know when M and his colleagues first read the pleadings in the translation reference, but what one does know from the agreed facts is that the pleadings closed at the beginning of July 2016, that there was a first procedural meeting on the 25th of July, at which by consent a preliminary issue was ordered, which may be dispositive. And one can see that defence, which gave rise to the preliminary issue, was the first defence pleaded by Chubb in response to Transocean's claim. And one can see that at volume 1 of S, tab 11, this is a statement of defence, page 162 or 406 in the electronic files. And conveniently, although like most Bermuda form pleadings, this goes on a length, conveniently there's a summary of defences at paragraph 13 on page 165 or 0409. which lists as the first defence a denial that Transocean has exhausted the minimum $750 million retention, and a denial that Transocean can use non-covered losses, such as fines and penalties, to exhaust that retention. Instead, it's alleged the retention must be exhausted by ultimate net loss, in other words, loss of the sort covered by Chubb's policy. And then there's an additional flourish that fines and penalties don't constitute damages. And then it goes on to list the defences that could arise contingently on the outcome of that, including the reasonableness of the settlement, to which I'll return.
This is June 2016.
July. I'm so sorry. No, the pleading itself. Let me find the date.
Well, close of pleadings, you said, was June 2016.
Yes, the pleading itself is the 13th of May.
Thank you.
The pleadings closed on the 4th of July. The procedural hearing was the 25th of July, at which, by consent, the preliminary issue was ordered. And as I understand it, directions were given for the trial of that issue. Matters such as disclosure on potential substantive issues were put on hold. So, my submission is that, A, given the nature of the reference, it was reasonable for M, even if potential overlap were a disqualifying or potentially disqualifying circumstance, to wait and see whether any problem arose. And B, the first reading of that pleading would have communicated to an experienced arbitrator the probability that a preliminary issue specific to Transocean would be tried before any further progress was made on other issues potentially arising, which is exactly what happened by consent. Now, on the timing, the preliminary issues in both Transocean references were heard in November 2016, and the application to remove M before Mr. Justice Popplewell was heard on the 12th of January 2017, at which time the Halliburton hearing, the substantive hearing, was due to start in 12 days' time, in other words, on the 24th of January. In the event, it was pushed back a few days. So, Mr. Justice Popplewell, we submit, was correct in observing that the possibility of any difficulties arising from overlap occurring in the future was extremely small. And one can see this at C12, paragraph 35 of his judgment. 412. It's page 216 or 217 in the electronic files. Where he says at paragraph 35, for these reasons, there's nothing in the acceptance of the Transocean appointments by M which gives rise to an appearance of bias against Halliburton. That is the position, even if the issues which had to be decided in the reference were identical or substantially overlapping. In fact, there is little risk of M having to address issues in the Halliburton arbitration which coincide with any issue on which he will have heard evidence or argument in the Transocean references. And then he says, preliminary issue turns on what you've just heard. The Halliburton arbitration is due to commence in 12 days, so that a final award can be expected within months. It is not known when the award on the preliminary issues in the Transocean references will be issued. If the preliminary issue is determined in insurance favour, that will bring the Transocean references to an end. If the preliminary issue is determined against insurers, it may well be that the tribunals in those references will not have cause to consider any of the material relevant to the merits of the substantive dispute until after the award in the Halliburton reference is published. Now, Lord Grabner says, well, this is all irrelevant. And I accept that if the circumstance which he says should have been disclosed, but which was not disclosed, was in itself disqualifying, then anything that happens subsequently is irrelevant. But if the obligation is to disclose non-disqualifying circumstances, as the Court of Appeal has found, then while the breach of that duty has to be determined at an early stage, as the Court of Appeal have observed, the question whether breach of that duty and other factors gives rise to disqualification under Section 24 has to be determined on the basis of all the material to see whether or not there is a real basis for doubting the arbitrator's impartiality, which in this case means there is a real basis for concluding that some procedural disadvantage, some unfairness has been visited on Halliburton. So I say that given that at the time of his appointment it was reasonable to assume that Halliburton would come to a hearing first, and given that he disclosed to Transocean what he had to disclose, his conduct was perfectly proper. And indeed, once it became clear that the Transocean arbitration would go no further until the preliminary issues were resolved, the risk to which Halliburton has referred simply is incapable of materialising before that event occurred. Now, I apologise to the Court. I've taken longer on the facts than I intended to do, but there is a danger in a case such as this that the actual facts of the instant case get lost in lofty discussions of principle.
Does what you've said amount to a challenge to the Court of Appeal's conclusion that there ought to have been disclosure?
Yes, it does, my lady. Whether disclosure is required as a matter of practice or an obligation.
Whichever.
Yeah, whichever. In fact, I may say so, Mr. Kimmins may have had a point here when he said that the argument as to whether the disclosure obligation arises as a matter of law or as a matter of conformity with good practice may not affect the outcome. Now, can I now deal with an important topic, which is the expectations of the parties that it seems, by common consent, being a relevant factor to relating to the question, what do you have to disclose? And that will depend to an extent on the nature of the arbitration with which we're concerned. Now, the Arbitration Act applies to any arbitration seated in England, Wales or Northern Ireland, both domestic and international. Accordingly, the Act applies to a wide range of different types of arbitrations of varying levels of formality, and it was drafted to accommodate all. It neither defines arbitration, nor does it impose a rule of disclosure. And in omitting to impose or incorporate a rule of disclosure, the draftsman, we would say purposefully, declined to follow the UNCITRAL model law, which provided conveniently for such a rule. Scotland went in a different direction and enacted, at least initially, this is impertinent of me to think that I'm saying anything that at least two members of the court don't already know, but we know, or at least I now know, that Scotland enacted the model law in 1990 under the Law Reform Scotland, Miscellaneous Provisions Scotland Act, and then in 2010 introduced the Arbitration Act Scotland, which applied in a schedule its own set of rules, which are an interesting read. I'll look at them tomorrow in examining the question of whether we are under, in England, an obligation in law to disclose. So it may be obvious, but depending on the type of arbitration in question, parties may have different expectations regarding disclosure of appointments and the likelihood of appointments concurrently in overlapping arbitrations. And we make the obvious point that if parties wish to, they can always agree to refer their disputes to an institution such as the LCIA or the ICC, which provides for the machinery that I've already described, namely wide-ranging disclosure following an answer and response preceding appointment by the institution's court. The expectations of the parties, however, will be shaped in a case such as this, such as that, in other words, an LCI reference, by what the rules provide, and there will be a contractual obligation on arbitrators accepting appointments under the rules to abide by the disclosure requirements, which, as we see, go well beyond disclosing disqualifying circumstances. Now, one of the reasons why the draftsman of the 96 Act decided not to adopt justifiable doubts as to an arbitrator's independence as a separate ground for removal is relevant to the current case, because one of those grounds was the perception that in certain specialist fields, parties may wish to sacrifice absolute independence for familiarity and expertise with the subject matter in hand. And we can see that at Volume 1 of the Authorities, Tab 2, which is the February 1996 Departmental Advisory Committee report on the Act. And the relevant paragraph is 101. It starts at page 22 or page 896 in the electronic files. At 101, the committee says that the model law specifies justifiable doubts as to independence as well as impartiality of an arbitrator as grounds for his removal. We have considered this carefully, but despite efforts to do so, no one has persuaded us that in consensual arbitrations this is either required or desirable. It seems to us that lack of independence, unless it gives rise to justifiable doubts about impartiality of the arbitrator, is of no significance. The latter is, of course, the first of our grounds for removal. If lack of independence were to be included, then this could only be justified if it covered cases where the lack of independence did not give rise to justifiable doubts about impartiality. For otherwise, there would be no point including lack of independence as a separate ground. And then it goes on to explain, we can see no good reason for including non-partiality, lack of independence, as a ground for removal, and good reasons for not doing so. And then at 103, we see this. Further, there may well be situations in which parties desire their arbitrators to have familiarity with a specific field rather than being entirely independent. And then just while we're on this, so I don't have to return to it, at 105, the court will see the Departmental Advisory Committee's recommendation for the creation of a new section, new in the sense that it's not found in the model law, which is now section 24(1)(d), which I'll come tomorrow. And that involves a failure properly to conduct the proceedings. And the links with 24(1)(d), we say, are section 33 of the Act, the duty to act fairly as between the parties and give each party a reasonable opportunity of presenting its case. And in the event of an award or a challenge to the award, section 68, as you've already seen. So there we have material for concluding that in specialist fields, the draftsman, aware of the fact that parties may wish to appoint arbitrators with the relevant experience and expertise, that might infringe some freestanding obligation of independence, which of course involves examination of the links between the arbitrator and the entity appointing him or her. Now, again, Mr. Justice Popperwell and the Court of Appeal were both alive to this point, correctly so. The judge, Mr. Justice Popperwell, was correct to observe that it was commonplace in insurance and reinsurance, as well as in maritime disputes, for arbitrators to sit in multiple arbitrations arising out of the same factual circumstances or subject matter. And you can see that again in the core volume, tab 12, paragraphs 21 and 23, page 211 of the paper files, 212 of the electronic bundles. At paragraph 21, he says, as to Mr. Kitchener's second reason, which you can find in paragraph 17, about 6 lines down, the second was that M would learn information during the course of the Transocean references, which was relevant to the issues in the H arbitration and available to Chubb. As to that reason, it is equally unsound, whatever the degree of overlap in the subject matter of the arbitrations. It is a regular feature of international arbitration in London that the same underlying subject matter gives rise to more than one claim and more than one arbitration without identity of parties. This is common in insurance and reinsurance claims, where there has been a large casualty and is a consequence of the spread of risk which insurance and reinsurance provides. It's common too in maritime disputes, where an incident may give rise to a claim under a bill of lading and one or more of a string of charter parties, and in commodity disputes with string contracts. In such cases, it's common for those with relevant expertise as arbitrators to sit in different arbitrations arising out of the same factual circumstances or subject matter. And then he says there are 3 reasons why that, in fact, is not only unobjectionable but desirable. At 23, if I may, I'll pick up the second. Secondly, arbitration is chosen in many contracts as the preferred form of dispute resolution because the parties desire their tribunal to have particular knowledge and expertise in the law and practices of the business or markets in which the parties are operating. Arbitrators with such knowledge and expertise who command the confidence of the parties often comprise a limited pool of talent. It is undesirable that parties should be unnecessarily constrained in their ability to draw on this pool if there are multiple arbitrations arising out of a single event or overlapping circumstances. And again, the learned judge goes on to say, well, that's really rests on the starting point that arbitrators will do their duty and decide a case on the material adduced in that case, an obligation they owe under Section 33 of the Act. Now, the question then is where one puts, and I hope I'm not overstating this, but one gets the impression that, at least in the case of LMAA disputes and GAFTA disputes, the rule for which Lord Grabner contends, namely a presumption, as I now understand it, that concurrent appointments in related arbitrations are disqualifying unless there is disclosure and consent by the non-common parties, effectively a veto. That doesn't apply, he concedes, or he tends to concede, perhaps I'm overstating it, in LMAA or GAFTA arbitrations. He draws attention, of course, to the rules in the governing rules which provide for consolidation in certain circumstances. But of course, those rules may not be referred to or applied. The arbitrations could proceed in parallel or concurrently without consolidation. But we submit that London insurance and reinsurance arbitration and Bermuda form arbitration, perhaps in particular, is much closer to these specialized fields where multiple appointments in related arbitrations are expected and regarded as unobjectionable, then references under institutional rules, such as those of the LCIA or the ICC, where, firstly, events giving rise to multiple references are much less common, and secondly, there are elaborate disclosure requirements which would probably pick up any such scenario. And the Court of Appeal and the judge below both referred to a passage in one of the two leading textbooks on the Bermuda form. Mr. Stanley QC is one of the three authors. Sir Richard Jacobs is another, and Laurelie Masters, who's an American attorney, is the third. And again, I'm sure you're familiar with this, but if you can bear it, I'll ask you to look at this passage, which you'll find in Core Volume Tab 9, page 189, 190 in the electronic files.
Was there some specific evidence about the practice in Bermuda form arbitrations in the interveners?
No, there was no witness statement, my lady, dealing with it. And
you just told us that in the Bermuda form arbitration field is closer to the fields in which multiple appointments occur, but I don't think there's any evidence about that.
no, there's the finding of the learned judge, an observation based on his experience. There is the textbook reference to which I'm about to refer. There is the Arias UK report, which was appended to a submission of GAFTAs, to which I will also refer. My submission would be that it's incumbent on the party seeking to have this arbitrator removed to demonstrate to the court that he has acted in a way which is exceptional or unexpected, thereby triggering an obligation to disclose if that's the path he wished to pursue. That's not, in the last analysis, an obligation on the respondent or on the arbitrator. It's on the party seeking to justify removal. But there is this material which enables this court to get a feel for what we're concerned with. Yes, I'll come on to that. There's also a reference in an LCIA challenge case, to which I'll come probably tomorrow, which recognises the small expert field under consideration, and also various American decisions. Again, one of which, at least, I will ask you to look at, a decision of the Second Circuit, which refers to the nature of this arbitrator's market, so to speak. But I won't weary the court by reading paragraph 52, because I'm sure, A, you've read it already, and B, you can read it again, if so minded, quicker than I can read it. But the gist is that it's common when you have either a loss which is either boom or batch, which means it's either an explosion, such as we have in Deepwater Horizon, a man-made disaster, or a batch, a case where, for example, a deficiency in a product, pharmaceutical product, for example, gives rise to a whole host of claims which are integrated together and regarded as an integrated occurrence for the purpose of presentation to the policy. But in either of those events, loss-causing events, what you'll have is a number of claims affecting the same vertical insurance program, and a series of successive arbitrations in which it's common for the policyholder to appoint the same arbitrator. Makes a certain amount of sense. And it's not regarded as objectionable or exceptional. And it's also common, according to the authors, for the parties to phase these references to see how a case goes before a certain tribunal. And the conclusion of the authors is that multiple appointments in overlapping arbitrations, and these, of course, are the same cases, same loss, same risk, just against different insurers. The conclusions of the authors are that these are not objectionable in light of Amec and Lockerbell. Now, Milady, I take the point that there is no formal witness statement, but a lot of the so-called evidence in this case is adduced by commentaries of people who've said something at an arbitration conference, or in the case of Mr. Stanley, whose opinion, of course, we take seriously, appears on the Essex Court Chamber's website as an offering. That's the nature of the beast we're confronting. And this is of that status. Now, in fact, we have quite a good example of the phenomenon described by the authors of the Bermuda Form, in this case, where N, Halliburton's arbitrator, was appointed concurrently in 3 different references arising out of the Deepwater Horizon disaster. Again, not related cases, but cases involving the identical issue, the same risk, the same loss, just affecting different layers and different insurers in Halliburton's vertical program. Now, Halliburton say, well, that's fine because there was no secret about those appointments. And it's true that they came to light at a very early stage. But when we look at the evidence, perhaps I can do this tonight and get it over with. It's in brief compass or narrow compass. What's not suggested is that N regarded it as incumbent upon himself to disclose to the non-common insurers the appointment he proposed accepting. What happened was that Clyde & Co. appeared for one of the other insurers in one of the 3 references, where N was Halliburton's appointee, and Halliburton, making no secret of the fact, applied for consolidation or suggested consolidation. Some insurers didn't want that, so it became apparent. But what's not suggested in my submission is that this was a circumstance or a set of circumstances which N, a very experienced arbitrator, felt he ought to disclose. And I can pick this up in a witness statement of a Mr. Thomas Bursick, who's Halliburton's attorney. It's in S, Volume 1. Tab 9, page 149 or 393 in the electronic files. And at paragraph 4.1 at the foot of page 149, 393, Mr. Bursick is responding to an earlier witness statement by Mr. Payton, in which Mr. Payton says, well, look, there's no problem here. In fact, Halliburton did it themselves with their own appointee. And this is his response. Mr. Payton claims that the position of M is no different to that of N, who was appointed by Halliburton in the present arbitration and at the same time in 2 almost identical disputes with other insurers in the same policy tower. There's not a reasonable analogy for at least the following reasons. N is a party nominee rather than a chair or umpire. Well, that's an American perspective where the chair is the neutral and the party nominees are de facto advocates, but it's not a consideration that weighs here. There's no question of N receiving a financial benefit from Halliburton subsequent to his nomination. Indeed, he had not been nominated by Halliburton as an arbitrator prior to the Deepwater Horizon arbitrations and has not been appointed since. Well, that begs the question of whether K&L Gates had appointed him in the past. We do know that in one of the references which M disclosed to Mr. Justice Flo, N was the party appointee of the claimant. There's never been any secret about N's multiple appointments. Clyde & Co. acted in one of the other arbitrations for the insurer respondent. As I say, they did, and it came to light. Indeed, in K&L Gates' letter attaching the request for arbitration and nominating N, we propose that all three arbitrations be consolidated. If this had been accepted, it would have meant that there could be no secrecy concerns. More importantly, it would have been obvious from the proposal of consolidation that Halliburton had nominated the same arbitrator in all three arbitrations. Again, that makes sense. The true question is this: suppose that Halliburton had nominated N as its nominee in one of the other arbitrations. Is it seriously to be supposed that ACE would have been content for him to have served as chairman of the present arbitration? Well, again, that drives a distinction between the position of the chairman and a party-appointed arbitrator that we simply don't accept, and we line up squarely with the LCIA, and as I understand it, the ICC. Perhaps I didn't get their position, but I think it's the same. I'll be corrected if I'm wrong on that. So the court will note that what is not alleged here is that N found it incumbent to disclose the proposed appointments and seek the consent of the non-common parties in each of the references before accepting them. And we don't...
I'm sorry to interrupt. I was just going to say, I mean, really, we've had three concerns about impartiality raised, and you've focused particularly on the first of them, which is that wherever there are overlapping issues, then there's this aspect of address rehearsal or secret communications. And the second is the idea that it's not playing the game for a chairman to accept nomination as a party's nominee because the nominee is effectively is not neutral. And you say that's American realism. That's not the British approach to these issues.
It's American. I don't accept the word realism. It may be real there.
Well, I was thinking of realism in the sense of Carl Llewellyn and theories about judges.
Yes.
And the third aspect is the point made in B, that the way it was put earlier was arbitrators have to earn a living, and here's someone who is and they earn a living in practice through repeat nomination by either insurers' lawyers or policyholders' lawyers, and here we have somebody who is, as chair, in a critically neutral position, becoming financially beholden to the insurer or the insurer's lawyers. And the way it's put in B is receiving a financial benefit from one of the parties subsequent to nomination. And we perhaps need to look at that aspect a bit more carefully.
Indeed, my top-of-the-head response to that is that this goes to the concept of independence.
Yeah.
And there may come a stage where a financial dependency is established, but there is no suggestion that this is one such case. The fact that an arbitrator is popular and repeatedly appointed is a credit to his expertise, to his skill as perceived by the market. There are cases, rather than giving rise to the risk that he or she is becoming dependent upon a particular source of appointments for their living. Now, there are cases which deal with that. There is a case called Coakley and Bingham, a first instance judgment of Mr. Justice Hamlin's, where, I'm trying to remember the facts accurately, over a period of, I think it was 5 years, I'll come back on the, I'll check it overnight, 25% of this arbitrator's professional income, he was a barrister arbitrator, derived from the source in question. And there were also a large number of appointments over a limited period. And when questions were asked about actually going to this question of dependency, the arbitrator's response was such as to encourage a perception of bias and further the case for justifiable doubts. It's an extremely aggressive response, quite unlike the response that we see in the correspondence in this case. So there can be cases where independence is found wanting owing to some dependency or other connection with an appointing party, but it's not suggested that this is one such case, and indeed there is no case for making that suggestion. Yes. Yeah. Yes. And of course, as Mr. Landau points out to me, there's joint and several liability for fees, and the absolutely standard procedure these days is, even in the case of ad hoc references, for deposits to be created equally by the warring parties and for costs to be awarded out of that fund at the end of the day. Clearly, any time an arbitrator is appointed, he or she derives a professional and financial benefit as a result of that. For a professional arbitrator, that's his or her living. But that's completely different from circumstances so extreme and serious as to create a position of dependency, which is what we're looking at. Yes. Again, I mean, I'm sure this is a point that you have very much in mind, but ultimate payment depends upon the costs of all.
Of course,
as you'd expect.
Yes.
My Lord, I was now going to go on to the Arias report. It's a slightly meaty document.
Yes, if that's a convenient point at which to adjourn.
To your Lordship.
Very well. But we'll sit again tomorrow morning then at 10 o'clock.